execution or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly CI 47 Order 22 Rule 11. My Lord, evidently CI 47 is the High Court rules. I'm well aware of that. But your Lordships have ruled in the election petition of 2012 and 2013, which is reported in a special edition of the Supreme Court of Ghana Report 2013. Your Lordships have made it quite clear that your Lordships apply CI 47 where there is no express rule that is in the Supreme Court rules themselves. And I don't know whether your Lordships want me to go through that authority. It is fairly well known. So your Lordships ruling in respect of the matter of interrogatories is to be found from page 50 of that special edition, and it was a ruling delivered on behalf of the court by Justice Badegbe. And the part where he refers to CI 47 is at page 54. Where he says, it does appear to us that the framers of the rules of this court envisaged a gap in the rules regulating the practice and procedure in the Supreme Court by making a provision to that effect in Rule 5 of the Supreme Court Rules 1996, CI 16. In this regard, we think that the current High Court Civil Procedure Rules 2004, CI 47, particularly Rule 12.6 of Order 11 on application for further and better particulars and Order 22 on interrogatories are beneficial to us by way of guidance as to the appropriate practice to prescribe in the course of the exercise of the original jurisdiction of the Supreme Court. It is it's Order 22, Rule 1, that is expressly referred to in that decision. It is to that order, it is to that order that we make reference when I stated that we're coming under Rule 5 and Order 22 of CI 47. And my Lord, that statement of His Lordship Justice Badegbe is further reinforced by the provision in Article 1284 of the Constitution of the Republic of Ghana.
Chair is regulating a movement behind it here, so you can.
And Article 1284 provides that for the purposes of hearing and determining a matter within its jurisdiction, and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority expressly or by necessary implication given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law. So the Constitution makes it explicit that your lordships have the power that is vested in every other court. I'm sorry, 1294. 1294. I read it right, but I didn't. 1294, yes. And my lords, the clear purpose of discovery under CI 47, the clear purpose. Yes, of discovery. Discovery, interrogatories are part of the process.
Okay, in that sense, okay.
And I refer to the broad scope of discovery because all those orders, further and better particulars, interrogatories, and so on, they are all intended to narrow down the issues for the trial and to make clear what really is in contention between the parties. That is what I wanted to emphasize. So what we have sought in these interrogatories, in our respectful submission, will achieve the objective of narrowing down the issues before this court. And my lords, all the proposed interrogatories, and there are 12 of them, in our respectful submission, are designed precisely to narrow down the issues for trial. Your lordships will, if I may respectfully refer to Order 22, Rule 1, from where your lordships will see, which is headed Discovery by Interrogatories. And Rule 1.1, a party may apply for an order giving the party leave to serve on another party interrogatories relating to any matter in question between the applicant and that other party in the cause or matter, and B, requesting that other party to answer the interrogatories on affidavit within such period as may be specified in the order. Rule 1.2 then makes reference to Form 10 in the schedule and Form 11 is the answer that would be provided. We have complied with the Form 10 in the schedule in indicating what we are asking for leave to serve by way of interrogatories. And your lordships will observe that starting from number 1 in the interrogatories, where, before I get into the specifics, there is another passage in the Judgment of Justice Badebe that I wanted to refer to, and I would respectfully ask your leave to do that before I go into the specifics. And this is a passage from page 59 to page 60 of the judgment. His Lordship says as follows: this leaves us with the application of the petitioners for interrogatories directed at the second respondent Electoral Commission. The application has been resisted on the ground that it has the effect of allowing the requesting party, the petitioners, to fish for information. If the said contention is correct, then the application must fail. We have carefully considered the application, and we are of the view that the request does not come within the designation of the word fishing as pronounced by Greer Law Justice in the case of Rofe and Kevokian, wherein he observed. And then he quotes that. And his Lordship, after quoting from that English authority, says, we have carefully examined the application relating to the request of the petitioners and are satisfied that they are within the scope of permissible interrogatory. So in that particular instance, the Lordships allowed the interrogatories to be served on the second petitioner. And that is what we are seeking for your Lordships to do in this case. In the specific interrogatories, we have questions regarding, in number 1, the practice in previous presidential elections involving collated figures from constituencies being received in the strong room in the presence of agents, and the further question whether that practice was followed, and the third question whether the 7th December presidential election was the first time regional collation centers have been interposed between constituency collation centers and the headquarters of the first respondent. My Lord, respectfully, these are matters which, in the answer of the first respondent, in paragraph 5 of the answer particularly, the first respondent sets out a procedure that the first respondent says is the procedure as detailed below. So, my Lord, these questions about the regional collation centers are directly related to what the first respondent sets out in paragraph 5. And equally, the question in question 4, how the results were transmitted from the constituency collation center to the regional collation center, that is clearly a question that arises from the process that is described, and that is clearly relevant. Yes.
Question 4. Should I understand it to mean the mode of transmission of the result? Is that what you are referring to?
That is correct.
Okay.
That is correct. And related to that, we also have in 6 a very specific question. Did the National Communication Authority facilitate in any way the transmission of results to the headquarters of first respondent? Again, that's a very specific question as regards whether the National Communication Authority facilitated in any way the transmission of results to the headquarters of first respondent. My Lord, respectfully, I mean, the issue of the mode of transmission is very important, especially for determining the authenticity of what was transmitted. And so it is very much at the heart of what is before your lordships in this petition. And whether the National Communication Authority facilitated is again capable of a very simple answer: yes or no. And in question 7, the interrogatory seeks to find out, when did Mrs. Jean Adukwe Mensah, is it Adukwe or Adukwe? Adukwe, yes. When did Mrs. Jean Adukwe Mensah, the chairperson of first respondent and the returning officer for the presidential election, first realize there were errors in figures she had announced in her declaration of 9 December 2020? When? This is a question only one person in the world can answer.
Mr. Chikata, why wouldn't you limit?
I'm sorry?
Why wouldn't you limit your references to the EC to the office, the chairperson, rather than the personality? It seems to me that your attack is against the personality of the person and not the office. So we'll be happy if you just limit it to the chairperson of the EC, because in her absence, any of the deputies, anybody at all could step in.
Respectfully, my lords, there is only one returning officer for the presidential elections.
And that is the
that returning officer is not the EC. That returning officer is the chairperson of the Electoral Commission.
And that chairperson, that's all. We are not interested.
The chairperson has a name. I'm not able to mention the name of the chairperson. No, my Lord, respectfully, I want to understand. Am I being prohibited from mentioning the name of the chairperson? Is that the issue?
Reading through your petition,
yes,
as to the instant application, the constant emphasis on the name. What I'm telling you is that we'll be satisfied just with the designation, because in her absence, any of the deputies could act in that position.
My Lord.
So if it is an election petition and you are challenging the election of the president, it is sufficient that the institution charged with the responsibility of conducting that election had done their work, and the chairperson, who is the head, represents that institution and not the personality, the name.
My lords, with the greatest respect, I believe that the constitutional requirements regarding the returning officer and the particular circumstances that we are dealing with in this case do not make it possible to have the situation that you are envisaging, where somebody else steps in for the chairperson. Respectfully, the Constitution makes the chairperson and only that chairperson the returning officer. And in the circumstances of this case, that chairperson happened to be the person that we refer to in the petition. And that chairperson actually was the person who undertook her responsibilities in accordance with the various constitutional and legal provisions that we have. So, my Lord, we do not mention her name by way of targeting an individual. That is very far from it. My Lord, when I cited before you a decision of the Supreme Court, and I cited the decision of Justice Gbadegbe as an individual judge, he read a unanimous decision of the whole court. I did not target Mr. Justice Gbadegbe when I mentioned his name, because he happened to read that judgment, which was a unanimous decision of the court. And equally, I do not target Mrs. Jean Adukwe-Mensah when I say that she made the declaration on the 9th of December. It's not a targeting, it's just a fact that is material in this particular petition.
So thank you. You may continue with your submission.
And that is why in the next interrogatory 8, the question is again posed: how did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent and the returning officer for the presidential election, get to realize there were errors in figures she had announced in her declaration? And respectfully, my lords, as I said in respect of question 7, there is only one person who can testify to those matters. And question 9, in respect of the purported corrections, and we put corrections in quotations because, I mean, whether there were corrections or not is itself an issue. In respect of the purported corrections made to the figures in the declaration by the First Respondent, was there any prior process of conferring with agents of the presidential candidates? And then 10, did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? 11 is on which date did Mrs. Jean Adukwe-Mensah?
Mr. Jikata, Adukwe in Ghana is a male. The female is Adukwe. She's not Adukwe.
I can only bow to the superior local knowledge of your lordship. So Adukwe, most grateful. My friends could not help me, but I'm grateful. I'm grateful to your lordship. Adukwe. And we seek to ask whether, that is 10, did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent, present Form 13, the Declaration of Presidential Result Form, to all the agents of the presidential candidates to sign? And if so, did all of the agents sign? And 11, on which date did Mrs. Jean Adukwe-Mensah, the chairperson of First Respondent, post a copy of the Form 13 at the head office of the First Respondent? And 12, did the first respondent record any discrepancies which were occasioned by computational and mathematical errors in the course of the collation of the results? So each of these questions, which is capable of a relatively simple answer, we believe will narrow down the issues that are before this court. Your Lordships will be aware that Regulation 44 of the Public Election Regulations sets out, particularly 4410, it sets out what the chairman of the commission, the CI 127 assumes that it will be a chairman, but the chairman of the commission it sets out exactly what is done in connection with the process. And the interrogatories that we are filing will, by clarifying these matters, will narrow down the scope of the inquiry before your Lordships. We have this morning been served with an affidavit in opposition by the first respondent. And I would simply say to your Lordships in this context that nothing in that affidavit in opposition provides a justification for us not being granted leave. My lords, in paragraph 4, following paragraph 3, in which the first respondent, which the affidavit is sworn to by Mrs. Jean Adukwe Mensah. And in paragraph 4, she says, I object to answer to paragraphs 1 to 3 as irrelevant as the steps taken by the first respondent is in accordance with the Public Election Regulations CI 127. My lords, with the greatest respect, whether they are in accordance or not in accordance is an issue before this court. Whether what has been done by her is in accordance with the Public Election Regulation is precisely an issue before this court. And that issue is not going to be determined by a paragraph in her affidavit. Indeed, my lords, the logic of the questions 1 to 3 should be obvious on the face of those questions. Questions 1 to 3 start from the practice before, to whether, in 3, whether the first time regional collation centers have been interposed between constituency collation centers and the headquarters of first respondent is in the 7th December 2020 election. So, my Lord, there can be no basis for saying that these questions are irrelevant to determine what actually happened, which is what this case is about. And in paragraph 5, she proceeds to object to answer 4, 5, 6, 7, and 8. Now, my Lord, 4 is how were results transmitted from the constituency collation center to the regional collation centers? My Lord, I mean, this question can hardly be irrelevant to this petition, because this question about how results were transmitted is critical for the determination of the authenticity that she's claiming for the results that she declared.
Mr. Chikata, could you kindly point to the paragraph of your petition that this question is related to?
The paragraph that is related to is the paragraph of the first respondent's petition, as I indicated earlier. Answer.
Which paragraph?
The first respondent.
Which paragraph?
Paragraph 5, I referred to earlier. Paragraph 5, where she sets out, where the first respondent, not she this time, the first respondent, Electoral Commission, sets out the 4-stage procedure.
Thank you very much. Thank you very much.
And so, my submission, the question how this collation was transmitted, or how the results from the collation center at the constituency were transmitted to the regional collation center, and how the results transmitted from regional collation were transmitted to the headquarters. Those questions 4 and 5 are clearly critical to what was actually done in this election, not just what is required to be done in general terms, but what was actually done. And, Lords, we cannot see how questions 6, 7, and 8 can be described as irrelevant either. And my Lords, in paragraph 6, with respect, what the deponent seeks to do there is to anticipate your Lordship's granting us leave, because she's giving an answer to that question, and respectfully we would like her to wait until you have given us leave to serve her, and then we can read her answer at that point. she is anticipating it in paragraph 6, and we are grateful for that anticipation, but that should await your Lordship's grant of leave, and the service on her, the service on the first respondent of the interrogatories. My Lords, there are other responses in the remaining paragraphs. I only comment on the one suggestion that we are unnecessarily attempting to delay the trial. Nothing could be farther from the truth. And we actually take exception to that suggestion and that averment in the affidavit. We take strong exception, in fact, I may say, to that suggestion that we are attempting. The purpose of discovery, as I've indicated, is to limit the matters for trial. And if only she would just stick to answering those interrogatories, I think the processes of this trial would be expedited rather than to make facetious statements about our intentions. We are therefore respectfully asking that your Lordships grant us leave, and I believe that upon these interrogatories being filed, they can accelerate the processes for responses from the first respondent, and therefore for the further processes of this trial. That is all.
Yes, my lords. My lords, we are opposed to this application. Lords, we rely on all the depositions in our affidavit in opposition. Lords, with respect, the answers to the questions being sought are in the petitioner's own petition, the answer filed by the first respondent, and also the answer filed by the second respondent. My lords, Regulation 44(9) of CI 127 sets out how the first respondent will declare results. And in it, questions being asked of us that where did the regional coalition center pop up from is all in the law. That is why we are saying that everything is in the law before this court. And those are the steps that the first respondent followed. My lords, my lords, with respect, Regulation 44 sub 9, the regional coalition officer shall, upon receipt of the presidential election coalition forms as set out in Form 9 of the schedule and the presidential election results summary sheet as set out in Form 10 of the schedule, from the district electoral officer in the presence of the public and with not more than 2 counting agents appointed by the parties contesting or the polling agents of the party, if any, assemble and collate the presidential results from the constituencies as set out in Form 10 of the schedule. Fill the presidential regional results coalition form as set out in Form 11 of the schedule. Fill the presidential regional results summary sheet as set out in Form 12 of the schedule. Request the, so my lords, it is all set out. That is where what is done at the regional level. And my lords, we have pleaded in our answer that indeed the petitioner had signed 13 of those forms. And my lords, we have also stated in our answer that where a party fails or refuses to sign on any of the forms at every stage of the process goes on. Yes, my lords. My lords, just a second.
That you are submitting before the court that your responsibility is stated in the law, as you rightly noted here. So, can you? I know, depending on the ruling of this court, you may have to answer or. But
my lords, regarding you are asking about question 4 and 5. Yes, my lords, as we have stated, I think somewhere in the answer is transmitted by fax. Now, my lords, we would also realize that the questions posed seek to introduce through the back door new facts which are not anywhere in the petition before this court. My lords, I wish to refer your lordships to the case of Nana Adodankwa Akufo-Addo versus John Dramani Mahama and the eeii. Lords, is reported at page 61 of the special edition of the Supreme Court of Ghana Law Reports. My lords, I would draw the court's attention to page 71, and with your kind permission, let me read what the court, the Supreme Court, speaking to Agyin Asare, said. In the circumstances, we hold that the petitioners are sufficiently and well informed about the election results, which has enabled them to mount this petition on grounds of malpractices in 4,709 polling stations based on the contents of these duplicate documents in their possession. The affidavit in support of the application does not disclose any need for the inspection and making photocopies of original documents. Lords, I wish the court to apply this decision and hold that the matters for which the petitioner seeks interrogatories are well within his domain, and he was well armed with those before he filed the petition in this matter, and therefore he is bound by his pleadings in the petition, and therefore cannot come through the back door and seek further information through these means. Lords, I would also wish to refer your lordships to the Metro Nunu case, Lords. Lords, it is Metro Nunu and others versus the Electoral Commission, 2007 to 2008, Supreme Court of Ghana Law Report, 1250. Lords, I wish to draw the court's attention, with your kind permission, to the obiter dictum of Dateban JSC. Lords, it says, it should be noted in particular that Article 49.3 requires the announcement of the results of the voting at the polling stations before they are communicated to the returning officer. Such announcement has the effect of putting the results in the public domain. Observance of Article 47 means, in effect, that the Defendant Commission publishes at each polling station the results from that station. We do not therefore see the need to imply as a condition of the validity of the declaration of the election of the President-elect the added publication obligation that the plaintiffs have argued for in this case. If the election system operated by the defendant could not function without such a publication, we could have been persuaded to imply such a publication in order to make the system workable. So, my lords, the point we are making, the submission I'm making is that there are over 38,000 polling stations countrywide. The petitioner appointed agents, at least 2, in each polling station. The results were counted, forms filled, his agents signed. If they refused to sign, it moved on to the constituency. They were collated. He had agents there. They signed. If they refused to sign, it moved on to the region, and so on. And then the returning officer, the presidential returning officer, got all these sheets. The petitioner's own agents signed 13 of them. The second respondent's agent signed 14 of them. Some of the 12 other agents signed. There was no total signature on all the 16, but based on the law, the system continued. So, my lords, the information that they are seeking are well before the court in the pleadings, in the petition, in the answer. And therefore, it's our prayer that this application be refused.
Mr. Amenuvo,
yes, my lord.
My understanding of part of the submissions of the petitioner is that in 2013, during the 2013 election petition, an application was made for interrogatories by the then petitioner before this court. And the court granted it.
Yes, my lord.
The decision given by Badebe JSC at from page 54. And so this is a similar application for interrogatories, which is before us. So this is being used as precedent.
No.
So what do you say? Because counsel is entitled to rely on precedent and invite the court to follow precedent already set out.
My lords, distinguishable precedent. Distinguishable precedent. My lords, with respect, the 2013 situation is different. And mind you, my lords, interrogatories, grant or refusal, is discretionary. And it has to be based on the set of facts at every situation. It doesn't arise in this case. It doesn't. And that is why I said, yes, there is precedent, but precedent is distinguishable based on the facts and the processes that are before you in the pleadings, my lords.
So why are you saying that in this particular case it is not applicable? In
my
this
lords,
particular petition, why are you saying it is not applicable?
Beloved, because the answer he seeks are all in the document before the court. And then the law that they themselves have relied on, which we also rely on, they are there. I just read to you the steps. You are asking me that when did the original issue come up, etc. If you read the law, you will see that it is in there.
Thank you.
Thank you very much, my lords.
My lords, I pray that I be permitted to make a few observations of law.
Are you making observations, or you should be permitted to respond?
Submissions.
I think the application is basically directed at the first respondent, because you will not be compelled to answer any question.
Yes.
If I understood counsel for the petitioner,
yes,
you are not under any obligation whatsoever to answer any of the questions serialized in the document annexed to the affidavit.
Yes, my lord, and it is true that no specific interrogatory has been directed to the second respondent. However, we are an interested party in this matter, and if we can assist the court on legal issues, we think we should be permitted to do so.
Yeah, Mr. Akujampa, if, as you rightly said, if it's a legal issue, if it's a question of law, we can hear you, because seriously you did not file any affidavit in position with regard to the facts.
Yes. That is what.
So, as a party in the petition and an interested party, if there's any legal point you want to address for the benefit of the court and all the parties, I think you can do so. Go.
My Lord, very briefly. My Lord, I think the first point to make is that interrogatories must relate to matters in contention between the parties. And that is clearly set out, my lords, in Order 22, Rule 1A, Rule 1, Sub 1A. It reads, with your permission, a party may apply for an order, A, giving the party leave to serve on another party interrogatories relating to any matter in question between the parties. My Lord, and it is further reaffirmed by 6A of the same rule, which states a proposed interrogatory which does not relate to a matter mentioned in paragraph A of sub-rule 1 shall be disallowed, notwithstanding that it might be admissible in cross-examination. So it's a well-established rule of the common law that a matter that may be refused in interrogatories may be allowed during cross-examination. So our position is that all the issues that they are raising here, and if you look at the pleadings, are not in contention. They have been sufficiently answered. There may have been admissions which put them out of contention. And the petitioner may have his occasion during cross-examination to throw some of these questions at the EC. Furthermore, my lords, it is our case that if your lordships consider the questions as to NCA, there's nothing in the petitioner's case that raises that matter as an issue. Very, very well. So my lords, that
allowed to make some raise points of law to assist the court.
Yes, my lord.
You are taking us
finally.
Yes.
The final point I want to make
is
that counsel for the petitioner referred to Badagbe JSC statement in the earlier presidential petition, but he did not quote Grill LJ, because what Grill LJ said is significant. And my lords, with your permission, I'll read from here. It is, however, the nature of fishing interrogatory trying to get, for the purpose of the defendant's case, evidence which he has not already got. On these grounds, having regard to what has frequently been decided, that because any question is a proper question to put in cross-examination, it is not therefore necessarily a proper question to put in interrogatories. We have decided that interrogatory 3 also ought to be disallowed as being a fishing interrogatory. And my lords, it is our submission that these interrogatories are indeed fishing interrogatories and should be disallowed.
May I, with your leave, just address a couple of points? My Lord, I would respectfully first observe that counsel for the first respondent in effect admits the relevance of these interrogatories, because he claims that they are dealt with in their answer. So there can't be any doubt that they are relevant. And the question whether they are in fact dealt with in the answer is the question that your lordships are going to have to decide. But he said that those matters in the interrogatories are dealt with in the answer. Now, my Lord, the second point I respectfully make is that he said that everything is in the law, and those are the steps that the EC is supposed to follow. We know that. We know what is in the law. But the interrogatories are designed to elicit what actually took place in order for your lordships to determine whether they were in accordance with the law or not. So you can't just keep telling us that everything is there in the law, everything is there in the law. We know that. But we have to establish a certain factual basis on which...
My Lord, with respect, is my learned friend re-arguing?
No, this is not re-arguing a point. He is responding to the issues you raised when you quoted the
Yes, but my Lord, it will have to be on points of law, as is the tradition in the courts.
Counsel,
yes, my Lord.
Let him proceed.
And my Lord, learned counsel also referred to what Justice Adingra said. And I believe he quoted from page 71. My Lord, I respectfully draw your lordship's attention to the fact that the decision of Justice Adingra was in respect of an application for further and better particulars. It was not the interrogatories. The interrogatories were dealt with in the decision of Justice Badegbe. And in her decision, in respect of the application for further and better particulars, her ladyship actually makes it clear she makes it quite clear that her decision is tied to the fact that there are other applications pending, including the application for the interrogatories. And basically what her ladyship was saying in the passage which I'm about to refer to is that those other applications are sufficient to take care of the matter which is being there. So that decision, which is about further and better particulars, respectfully cannot, respectfully it cannot be a basis for the submissions made. And as regards the reference to an obiter dictum of Justice Dateba, the less said about obiter dicta in this particular case, the better. I respectfully submit that far from us coming through any back door, we are actually coming through the front door of the Electoral Commission based on their own answers in order to ascertain the facts on the basis of which this court can reach a just determination.
Yes, for my edification, question 6. Question 6.
Yes, my lord.
How does it relate to the pleadings so far filed before this court?
My lord, counsel actually claimed that they talked about faxing. Now, all these communication systems, phones, faxes, fall within the authority of the National Communication Authority. And therefore, my lord, therefore, a question as regards whether there was any facilitation by the National Communication, my lord, I need hardly acknowledge that, I mean, the security of, communications in terms of an election process, all those matters are clearly important in the context that your lordships are faced with. So the question whether the National Communication Authority as the institution that is legally mandated to have responsibility for communications facilities in the country by law, whether they facilitated in any way the transmission of results, my lord, is an appropriate question. Respectfully.
Mr. Chikata, this is not one of the grounds which you have stated in your petition for invoking our jurisdiction. Look at your petition. It's not one of the grounds. The mode of transmission of the results is not one of the grounds.
My lords, with the greatest respect, the mode of transmission cannot be a ground for a petition like this. The mode of transmission cannot be a ground. The mode of transmission becomes relevant in an adjudication related to what the first respondent is claiming was done. The first respondent has filed an answer and makes certain claims. Now, my lord, those claims don't need to appear in our petition to be relevant. Those claims are the claims that are put in answer, and therefore issue is joined in respect of those claims that have been made in the answer. So the question that we are raising about the mode of transmission is critical, because it is a question that enables this honorable court to determine the authenticity of whatever transmission took place. That question is extremely relevant, and I believe learned counsel for the second respondent claimed that it can be asked in cross-examination and so on and so forth. But we don't need to wait for cross-examination. The purpose of dealing with it at this stage is to avoid having to go through lengthy cross-examination.
Thank you. Thank you.
The petitioner applicant has prayed this court to grant the application to serve interrogatories. The basis for the application, as argued by learned counsel for the petitioner applicant, is to assist the court to narrow issues for the trial of this petition. Interrogatories under common law is discretionary. It should be granted or refused when all the circumstances are taken into consideration. It should be noted that the questions seek to elicit should relate to the issues raised and the relief sought in the petition. Interrogatories must be relevant to the issues and relate to the matters in controversy between the parties. In this petition, the petitioner and the first respondent. The court is of the opinion that the crucial issue of relevancy has not been established in this application. Reference was made to the 2013 election petition titled Danado Dankwa Akufo-Addo and two others versus John Dramani Maame and two others, 2013 Supreme Court Organo Law Report, Special Edition, page 50, in which an application to serve interrogatories was granted by this court. However, subsequent to 2013, several statutory amendments have been made by CR 99 of 2016, which has restricted the practice and procedure of this court as regards election petition. Indeed, Rule 69C4 of the Supreme Court Amendment Rule CR 99 directs the expeditious disposal of the petition and sets timelines for this court to dispose of the petition. It implies that even amendments ought not to be granted, as well as joinder of parties. Subsequent statutory amendments pointed out after 2013 have provided us with new procedural regime and strict timelines. We are strictly bound to comply with CR 90, and therefore we will not apply Order 22 of CR 47 of 2004 in these circumstances. We accordingly refuse to grant the application, and same is accordingly dismissed.
You are grateful to the court.
I am most grateful.
Yes, please may I have your attention. Indeed, we set today, we adjourn the matter to today for case management so that we can have the consensus from both parties and proceed to hear the petition. So we hear from you the issues which you think should be set down for. Try. Yes. Mr. Chikata, we want to, we are seeking the assistance of both counsel to, give, all counsel in this case to give us some assistance in arriving at issues so that we can proceed to make consequential orders.
Well, my lords, before we get into that, I may say that we will urgently require a certified true copy of the ruling that you have just delivered so that we can advise ourselves in respect of that. And if we can have it by the end of the day, that would assist in the further processes that will take. Now, secondly, my lord, as I indicated right at the beginning, we have served a request to admit facts, which is a request we have served on the first respondent, and we have also served a request to inspect documents. Now, my lord, in respect of the request to admit facts, again, that is in the nature of a process of discovery, which also comes under CI 47, and we have the clear understanding that in respect of that also, there are a number of days within which we have indicated 3 days within our request to admit facts. Now, that is not an application before you at the moment. I recognize that. However, I'm drawing your attention, the attention of your lordships to it, because that will also affect whatever other steps are being taken in respect of this case. So I think we recognize that you have just given a ruling about the operation of CI 47 and how it's affected by the subsequent CI, which we will advise ourselves on once we have it. And I think that that will guide the process of our recommendations in respect of the case management. The final thing I will say is that I think, as is fairly normal, we are quite happy to set down the issues that are arising from the petition and the respective answers, and put that forward so that it is considered by council. I do not think that is a process that is easily done just on one's feet in a courtroom to try to determine what are the issues. I think that a normal process is perhaps for us as petitioners to put forward issues, and we are happy to undertake that with as much expedition as is consistent with the interests of justice.
My lords, we would seek further direction from the court whether the court wants us to raise our issues now or we should file a process. Because we...
Sorry. A process in what form?
Well, that we
want you to file issues so that you settle on it. Maybe by tomorrow.
Well, my lords.
Mr. Kutampa. Yeah. Mr. Chikata.
My lord.
Yeah, please, can you oblige us so that if...
My lord, I think tomorrow is a stretch because, one, I don't think we can respectfully do it by tomorrow because, first of all, respectfully, we are going to advise ourselves in respect of the ruling you've just made. We are going to take that into consideration because your ruling, as we heard it, seems to relate to the operation of CI 47. And so, since these processes of issue, they are not provided for in CI 127, the CI 99, they are not provided for in CI 99. There is no specific, so again, normally we would be guided by what happens in CI 47. But that's why we need to understand your lordship's ruling, and once we get it, I think we will know what steps to take. But I think tomorrow it will not be possible for us to submit.
Try to be a bit flexible, because if you look at the operative rules, there is no provision for amendment. But we thought it is inherent in the court of law, to be very flexible, to allow amendments. But whatever it is, if tomorrow is not convenient to you, because we thought having settled the pleadings, at least you can unearth the issues. Yes, by tomorrow, so that we set the what do we call it, the case management in motion. Yes.
If Thursday is acceptable, by Thursday we should be able to put.
Yes, Mr. Kutampa, excuse me, please.
My lords, today was set up for case management, and all lawyers know that case management involves determining the issues for trial, and all of us should have been prepared for that. It is not acceptable that any council may suggest that when a date has been fixed for case management, especially in the circumstances of these proceedings where expedition is very paramount, to come to court and make an application that they should be given time to think about the issues. But that is highly unacceptable.
Please, so it was overtaken by events because there was an application which had to be determined. Yes. No. And
my lords,
we adjourned, the court adjourns a matter. We adjourned it to today. For pretrial.
Yes.
Case management.
Yes.
Then an application was filed.
Yes.
And we thought that it was prudent on the part of the court to take the application, and you've taken it. So if we adjourn it tomorrow, we hope that you can do us a favor and file the issues. Yes.
Very well.
Because we don't want to impose the issues on you, but ultimately it's the court which will have to consider the issues which parties have filed, so that we proceed on the common ground.
My lords, if we can take a cue from the precedent of the 2013 petition, this matter of issues to be tried was determined in open court. So it seems to me that if your lordships are directing that we come tomorrow for that, we should come and read out our issues and for the court to take up the issues.
Okay.
Because filing these matters may take some further time.
If you prepare it in the morning, you cannot meet at the registry. Sorry, file it at the registry.
We are ready.
In the morning.
Very well.
We are ready. We are ready.
Otherwise, we are just concerned that this matter be dealt with very expeditiously.
We are ready. We are ready.
My lords, I believe that I've indicated that it would not sacrifice expedition if we had until Thursday, because we also need access to a ruling that you've just delivered. Yeah.
Let the issues for determination be filed by tomorrow before 9:30 a.m. The case is adjourned to 9:30 tomorrow a.m.
All rise.
Adjourned speaks in the Supreme Court joins me right now.
You make sure say ma attend you know every ketwa na enkoye tatra. It normally no obia person di asema ekosino petition our petition reply you be share issues for trial. They be important so akawasem so there be narrow issues but also be one the chairman so assemble akrono 1,000 the court will say on managing the issues assemble team be na kofi dia ba say ye court etra so e kasam na tatutikata any president mama I decided say I'm filing motion ya some motion of an interrogatory motion meaning say in some of the court no omo per say omo be sa easy in Self-Webia, South Zafano, say yes, Jituma, say, Omo did this, Omo the evidence be proven. What's the normal? The rule of the game is evidence. Anytime they are, Udi assemble to no, a fact. And the fact was not a fact in issue, meaning assemble, assemble, as you who say, a no quarter and no quarter. Nanya, ultimately proves that the quarter and no quarter, the evidence. But I told you, I don't need to be obi chimansua. For example, remember example, Ebia, Obaha. 2 o'clock. And Afia 3 o'clock. Na as a bedi asem, na bisa say, ube tumaja to me say ubaha na. Now see me baha. Then the issue whether ubaha number or no. Me bisa o. Because wakasa waja to me say ubaha. But so can say umba. And they say assembly evidence to show say ubaha. Omo na be say seminya CCTV camera. O di say. When you be make so good. Okay. And you know interrogatories, you know. Na chachu kata wo so be any say. In same way be one move bisa easy. Na say easy jutum say eyan no say any say some na waja to de. E ba try na me find that same ba. Into no ebi ni say omu bisa easy say easy wakasa kwa fa so a odi quality results no 50 constituents urban regional urban no kwambe so na fire e fe so no kwambe so na results no ye transmit ye odi say ye dey fa facts and now ye dey fa e fe so whether when say national communication authority a part of it and now odi say national communication authority actually no do they play any role in determining transmitting these results? All these issues, no, Supreme Court are raising, Chachu raising those issues before the court, and I think what has happened is that argument be akoso. Now the year then say Chachu kata, to me pressing court no say questions on bisa no, here relevant, bibia, say bisa. Now easy no, the year say questions they are being or answer yes or no. And the point in some that court edim no sansem no enye tenten even in cross examination every teacher and na isi so can say ewu ya chatuti kata then in court for per se in some omodi to court omodi to court no omo pe kwa bi so ewi omodi fufuru bia be kan o no no odi asem bia o file petition nyama e petition no you have to stick to it
and no wasam ne
yeka
Wontumi nka bi before asama what ya wodi ka dia
Dokono. Okay. Say kwa fa so a ye transmit you know enka petition o. Say who be some question wo. Na say person uwia asam and be ka ho. And he say and this wontumi ko back door. Wontumi faith here. Enko fa nsema wankasa any petition mo. Na wo share be bisa yen. Na wo do ya no. Na ye answer o say ye kan ye. And I used to say, Assembia, Mumu, who be saying, what interrogatory, no. Sassam answered that. Sassam now the bow.
Their response to the
response to your answer, and to all person who delay that is. Never here. A first no, Brano is straightforward. Near yes, no, or follow regulation. And to own regulation, no. And that in our own train, I say, yes, sir, as somebody else here. What was the question? Ten said, oh, baby, some questions. Now, answer. Into also did as a no. Anna, lawyer, Akoto Ampa, my own namesake. Also sorry, Anna, Jesus says, and I'm also a man anything. Papa, one money anything, I want to do. Yes, I can use them. Who, yes, will be. Yes, I will be Mray. Anna, is in every son as them. Now, also, Becca would not say, and the current say, interrogation, no. Young man, copy. And follow only there has no legal obligation to answer. But Esther said, easy answer or the follow or your interested party. Nanado will either be affected positive or negative. So, and to only the point of law, no, so educating Supreme Court judges no. After all, asam no, obi to be unimoko. And you know, say this is easy asama. Also, person Oman court who say, Chachu kata eya diabolic. Because law now na kasa koti you know or pekwe bi so na wakofa evidence anyhow now they be ka or they be ka the petition ho they say court man o kwai and you know and the argument you could do and if you do tell me na fere tell me for side this here we be say Chachu cheta question kakra e bi say easy lawyers go kakra it is no omo ma breaker omo kwa ko decide say questions are Chachu cheta any mama Edema is you know. Uncle answer and now uncle answer. Near so answer and near so answer no. And now more pay more or more could do no more aba.
Okay. And this eba nessa oba answer. No sir electoral commission bra na chachu busa busa ne ansem no na oyi anu wi a o mato aso.
Yes, they say no say chachu get a bisa permission because person bisa leave the permission was court. Now for the court no on ban say okay focus serving no questions are bisa no for the money answer formally. They say no we file it no or serving no. You see a year bia no at the abonegu say me ebi wa me answer. And as you say, my lord, yes now questions are ebi say yes no or person answer B ebi so on person answer until my point na your man order now questions are money no uncle answer until the Supreme Court ever decided whether questions are Jomama any easy for example Jomama any certificate episode obisa yes no say what the my yes na easy answer ni na more answer anona esisi ano court no ahumujiem na omode results aba. But what is important is that say about the sa na court jitum say yen koko answer and yisi ye be adjourn case no ama yisi akọ answer. Say about to say court to say questions are you be say on to the question no and questions say yisi akọ answer obegbu. But me whether one man no quite answer your man no quite answer exams and the questions no obi without question answer according to your ability and to be the way the answer no so any answer you mark you o dey say obi sam na minim me say minim da minim and the end niawo purpose of person answer no answer the aba and I think say in all fairness no I'm foreseeing say the Supreme Court is likely to grant the application because to me questions be why answer it doesn't mean say when I say okay say bad and not case good
na chachu na say end this lesson no omo kire and some party omo zo mbusa maame no e ma ni yeah
omo kire bi ni say person omo from maame say point fast so resource no what the fee one police station at the back constituency and bar regional never national. So National Communication Authority play role be meaning National Communication Authority facilitate like on a boy other two facts and then be a telephone and now other means what they buy you know. I don't know now easy like they can say eunya because which I choose I hope so who is as a man that offer petition one making it part of your state your case say yeah ko ni me first ko bisa e bi so dey say kwa fa so yisi e declare the results no bro yeah mistakes no all correct no obobi amane and now omo I saw mo agents no all correct you know omo obi sign answer na all more results na they are very interesting interrogatories and me I prefer say yisi should be given the opportunity to answer. You see one thing I hear who petition no is the learning process. It's good for reforms. Okay. Because normally, I believe, say, through the court process, instead of people going on the street to demonstrate and cause him, rather, we should allow the EC to be accountable in the court. Once the courtroom, propaganda, and who watch here, say, people like Asiedu Nketia We're, you can't talk there. How do I say? Can we tell them you can't talk there? Now you are talking about law. And propaganda has no place. Until I believe, say, if the EC is allowed to answer those questions about what in the way forward, when we have election, when we have elections, if you are ECR,